HIV, and at birth, HIV gets transmitted between a mother and a child if the mother is HIV positive. It doesn't happen in the womb, it happens at birth. Now there was a drug called nevirapine which basically stopped the transmission of HIV, or reduced the likelihood of transmission of HIV at birth. And the government was offered the drug for free in the public sector. And ultimately the government said, look, we have to investigate, we have to see, we're only going to make this available on a limited basis across the public sector. We're not going to make everyone have access to these rights. And a group called the Treatment Action Campaign formed, created a mobilization in society, and brought the case to court. And it said the government has a duty to provide healthcare services for individuals. And the court said, wait a second, we're going to use the doctrine of reasonableness. Is it reasonable for the government to refuse to provide a drug that is provided for free to individuals by the pharmaceutical company, and it has a strong chance of preventing transmission from mother to child? The court declared the government program unconstitutional, and it fundamentally changed government policy on HIV in South Africa, right? The government at the time had been denying that HIV in fact caused AIDS for bizarre reasons, and the government program essentially fundamentally changed. And South Africa today has one of the biggest antiretroviral treatment programs in the world. And that is partly as a result of courts taking their responsibility seriously in relation to social rights. So if you want to know the power of social rights, it has the power to save lives, as occurred in that particular case. In fact, Harvard University did a study, and they say because of the denialist policy of the previous government, a few 100,000 people probably died. And you can imagine, once that changed, how many people's lives have in fact been saved. So what models should we adopt in relation to social rights? And I know I have sort of limited time, so I can't address you this in a lot of detail. Well, you need to consider, in Egypt there are various advantages and disadvantages of adopting models that were adopted in Latin America versus the approach adopted in South Africa. In Latin America, if you have a problem and you can't get your rights, you can write a letter even to the courts. The court has to look at it. You don't have to go to a fancy process, and it has to give a judgment within 10 days in relation to your right that you're missing. And essentially that's it's an action called a tutela, and I recommend looking at the Colombian constitution there, which has got this very interesting action, and it has created a tremendous sense in which the constitution belongs to the people. It belongs to the poor. They can actually access rights directly with the courts through going straight to the courts and ensuring that their rights are realized. Of course, the problem with an individual model is it's difficult, because if you have a lot of individuals coming with claims, it messes up the possibility of developing a proper, coherent healthcare policy overall. So in the realm of healthcare, the Colombian court has also, on top of having individual remedies, sought to address things from a programmatic point of view, and sought to look at the program of the government and what it's in fact doing. So one of the issues that needs to be looked at is the program, and whether to adopt an individual or programmatic model. The second issue is, what's the standard of review? Is it reasonableness? As I've suggested to you, I wouldn't recommend that approach. I would recommend a different approach, which is I refer to as the minimum core approach, based on, those of you who are familiar with the Covenant on Economic, Social and Cultural Rights, you'll know that was the minimum core is a notion developed in General Comment number 3, and ultimately requires the development of a minimum essential level of a right. Okay, and in my book I try to define what that is. I define it as the general conditions necessary to ensure that one is free from threats to survival. Okay, we can debate whether how good that standard is, but that's the minimum essential level of a right. And from that point, the government has some discretion to develop a plan on which you essentially attempt to achieve more than mere survival, to achieve living in a situation of dignity. But in a state like South Africa, and I would venture to say Egypt, with a strong, difficult economic situation, it isn't possible to provide people with exactly what you want now, immediately. So it's important to create a shifting standard from a minimum condition that no one can go below up to a higher level which can be achieved as the economic circumstances allow. And if one's going to create workable socio-economic rights, in my view, there's an absolute necessity to ensure you define a standard, a minimum, and then try and achieve a certain review of how the plan works beyond that minimum. Some interesting provisions are in the Kenyan constitution, where in fact the state is required to show that there are no resources available if they claim there are no resources available, and in allocating resources the state must prioritize the most vulnerable. And those are very interesting provisions which help achieve and ensure that these rights go beyond mere paper rights. Apart from the doctrines of content, it's also very important about the relief that courts are able to give. And your constitution at the moment also doesn't have, the drafts are changing, but it didn't have any flexible remedial provisions that allows judges to actually craft sensitive remedies to ensure that relief is realized, that proper relief is given to people in these circumstances. In South Africa, they've often required, sometimes the government comes in and throws people out of their houses, and the courts have said you can't treat people like that if you believe that they have dignity. The government has to engage with the people. They have to talk to them, and the court forces them to mediate and to engage and work out a solution for the future. That's a very creative remedy. The courts in South Africa also sometimes, and in India, they supervise the implementation of particular rights and what's happening. They watch over what the government is going to do. And it's a very interesting issue to actually see how the courts sometimes have to adopt a managerial role almost to ensure that other branches realize their rights, the rights of individuals. The last issue, which I can only address briefly, is separation of powers, which is always raised as an issue in this area. Do courts have the legitimacy or the competence to engage in these things? And what I would say to you is this is not a bar to courts' involvement in the area. Courts are not experts on economic policy, but they can draw in expertise on economic policy. They can have some testimony, and if they're not happy with it, they can actually send the matter back. They can say, this is unconstitutional as it stands. We're going to send the matter back to the legislature or the executive to pronounce on it, and then they will come back to court, and then we will see whether it conforms with the rights. And that's what's called a more collaborative approach to achieving socio-economic rights, where the court isn't always in competition with the other branches, but it works with them to benefit from its own expertise, which is ultimately in the area, or should be in the area of fundamental rights, and ultimately helps and then draws in expertise from others as well. Okay, so there's a different model of separation of powers. I'm going through things very quickly, I know, because of time, and I'd like to have an opportunity for one or two questions perhaps at the end. So in brief, at the moment, the social rights in the Egyptian constitution, as I see them, there's been some improvement in the draft I saw yesterday, but there isn't really a grappling, okay, with how to make them meaningful promises. There needs to be an ensuring that there's some standard set, there needs to be some minimum, and there needs to be adequate enforcement mechanisms and institutions that are put in place, perhaps even a commission to help realize those rights and make them meaningful. I hope this has been of use. Thank you.
So as I briefly said at the beginning, due to the travel arrangements, I would like to open the floor now for maybe one question or two. So I saw a hand right there. Can you have the microphone?
There was some here, I saw some two here.
There were two.
Okay, why don't you?
I can just go here.
Yeah.
But actually, thank you very much for your lecture. It's very interesting. I'm a journalist. I have a problem with, terms like socio-economic what do you mean by socio-economic, and you are waiting until you know fulfill all this. It's a little bit difficult for an ordinary person like me. What I love also is about that Latin experience, like that somebody can send a letter to the court and then the court has to respond directly. That shows that there are a lot of, a practice everywhere, but the common thing which I cannot understand until now, if we are always amending the constitutions everywhere and trying to make them going better for the benefit of the people, so why from the very beginning there is no one is sitting down and asking why the constitutions are not fulfilling the rights and the needs of the people from the very beginning before putting it? Why there is a conflict? Why we have to call the word bridging? And thank you, and sorry for talking.
Okay, should I go? Yeah. Look, I think obviously I'm using very technical language, so I apologize if that's the case. I think that it's a very difficult issue for the Constitution to solve all the problems. The Constitution can set the goals and can set certain standards that must be fulfilled. Its language can help ensure that those rights are realized, and its institutions can ensure that things happen properly. So like you say, that letter to the court is a very important thing. The court has to respond in 10 days, and that's made a big difference. That's a very interesting thing for Egypt to consider, ensuring people can get to court. In my country, it's very difficult for people to get to court. So it's very good if people can get easily into court. One point I make as well, one concern I have had while I'm in Egypt is that the judges are driving the drafting process of the Constitution, and they to some extent are enshrining their power, too much power on the judge's side. There needs to be some balance with the judge's power. And it seems to me that, for example, I read a report today that judges are now are seeking to prosecute people who have criticized the judiciary. That is a flagrant violation of judicial power. I criticize the judiciary in South Africa all the time, and it's a fundamental way of holding the judges to account. And there needs to be, judges need to know that they are accountable to people through public discourse and through the academic community that exists here.
Maybe you have a second question over there, Susan?
Thank you. It's really great to hear the Grootboom case from a South African, because I teach that case. We love that case. It's an awesome case. But the reason that the judge could reach that decision was because South Africa's new constitution directly incorporates the Convention on Economic, Social, and Cultural Rights. And so how would you propose a parallel for Egypt? I don't imagine that kind of incorporation is anywhere on the horizon.
Why not?
Okay, so just to make it clear, South Africa actually, one of the strange things about South Africa is it still has not ratified the Convention on Economic, Social and Cultural Rights. I don't understand why that is the case, but the government has not ratified the convention. So the convention is not really applicable in South Africa. So what the court did is essentially it based its reasoning on the rights that exist in the Constitution. So my view is that for Egypt, what really matters is that the rights get defined well in the Constitution. I did see a provision yesterday taking and saying that human rights provisions from human rights treaties will be recognized. Okay, and that's an improvement on previous drafts. I would also like to see something about customary international law in the Constitution in Egypt. But from what South African court did is it did all its work on the constitutional provision, and in fact it separated its approach from the Committee on Economic, Social and Cultural Rights because of the difference in South Africa. We think that that was kind of, I personally think it's sad that South Africa didn't try and develop the minimum core approach and went on its own sort of its own way of achieving things, which has actually weakened the rights a bit. So I would suggest a stronger approach for Egypt if you want to make sure that the poor actually have those rights.
One quick last question.
Thank you very much for really a fantastic intervention. With regard to the international covenant, in fact, international covenant is included by the provision that all international instruments to which Egypt is party have to be, are directly enforceable. And in fact, in 1986, there is a ruling by a court of first degree about the right to strike. The right to strike is not recognized in Egyptian law, but because it is recognized in the international covenant, then it is applicable to Egypt. But now, I have a question to you. With regard to what you said about the Colombian constitution and any individual having the right to, wouldn't this really flood the judiciary with so you see, I mean, look at Egypt, look at the deficit in housing, look at the deficit in potable water. So I think that the right to resort to courts should be somewhat regulated. So what do you think about that?
Yes, that's a major problem. Like you say, there is a worry about flooding courts, and in Colombia the courts have in fact had lots and lots of actions. In a way, the courts have embraced that, and they've taken that and they've said, we we are courts there for the people, and we try. It's a very big burden on the judges, of course, but they attempt to realize the rights of the people strongly. They've also attempted through doctrine now to consolidate various actions together. So, for example, they had a huge amount of tutelas on internally displaced people, and they've now created, basically, they linked them together to say that they had to be a systematic approach to address, in terms of this particular judgment, the plight of internally displaced people. So I think courts can be clever as to how they manage that process of flooding, but I think it's better in some senses to have access to court if there's no alternative. And I worry in Egypt, where are people going to access their rights from if there's no proper human rights commission, if there's no proper institutions, then you need to increase the access to court. So it seems to me that there may be a balance to be achieved, and South African court regulates its load by a thing called the interests of justice. Is it in the interests of justice to hear the case? And they will hear cases that deal with pressing need. And India as well. So the Indian court also opened its gates, but it is swamped, and then justice takes longer in India. So there is a balance to be achieved. You can also increase, I suppose this is for a law school or a university, you can also increase the number of graduates. You can train graduates, more graduates. You can increase the number of judges. So there are ways of addressing those kinds of issues. But I think if one's going to take rights seriously, one's going to have to address, if people are going to be excluded from the courts, then it's not going to, then one isn't going to make any progress. So one has to address what are the sources, and I don't know the Egyptian context as well as you do, but what are the sources of exclusion at the moment that prevent poorer people from gaining access to their rights? Because the 1971 and then 2012 also included social rights, but I don't think the position of people has really changed. So how do we make those rights meaningful? That's been the sort of tenor of my presentation, to try and sort of discuss lessons. And I'm happy to share some. I have shared a paper of mine previously, and I would, as I say, I would like to just wish everyone the best of luck with the constitution process. I've got some flyers here for discounts on a book on business, on the human rights obligations of business, which is just about to come out. So those of you who want to get them, you can come afterwards. And good luck with your constitution process, and thank you.
So we proceed with our second speaker, who has also historically looked at how constitutional transplant moved from Germany to the South African case. So it's our bridge to this second part. You have the floor here.
Thank you so much.
Cheers, guys. Thank you.
Thank you very much. I would like to... Is this microphone on?
There should be to the side.
I'll let the expert handle this. It is on. It was on all the time. Oh my God. I would like to thank the American University here in Cairo for this event. It's a pleasure being here. Dean El Baradei. I'm impressed by this wonderful, wonderful venue. I will suggest to my dean at Tulane Law School